Welcome everybody. Thank you for joining us here today. I think most of you probably know me, but just in case you don't, my name is Alex Nassif. I am a membership and training coordinator with the Iowa Coalition for Collective Change. And I just have a couple of housekeeping items to touch on before we get started. So we are being recorded. This recording will be uploaded to YouTube shortly. So you can go back and watch it or send it to your colleagues who weren't able to be here with us live. We may have folks joining us today who are not advocates, who don't have confidentiality. So please be careful not to disclose any identifying information or anything that would lead someone to figure out the identity of anyone that you're working with, any survivors that you're working with. We do have both closed captioning and ASL interpretation happening. So please, if I unmute you to ask a question, just make sure that you're talking at a reasonable pace so that we can make sure that captioning and interpretation is able to keep up. And then please, if you haven't already, use the chat to type in your first and last name and the program that you're with, just so that I can take attendance and send out certificates of completion so you can all get credit for being here. And also, if you have any questions, you have a couple of options. You can chat in the chat box like you normally would. There's a Q&A box as well that should be in the menu, I believe, at the bottom of your screen, or you can raise your hand or chat me to unmute you, and you can verbally ask a question. All right. I see a lot of folks typing in the chat box just with their names and programs. Awesome. Thank you so much. So with all of that housekeeping out of the way, this is the fourth conversation that we're having with all of you around issues related to the COVID-19 crisis. And today we are talking with an attorney with Iowa Legal Aid. This is your opportunity to ask questions around unemployment, rent, mortgage issues, anything around general assistance, any other barriers in that kind of arena. And even if Margaret might not have all the answers right away, it also helps us to know what kind of barriers you're encountering or what questions you have going forward. So with that, I'm going to introduce our guest speaker and we'll get started. So Margaret Weirich or Weirich, or how do you pronounce your last name? Sorry.
Weirich, like a K
Weirich.
On the end.
Got it. Weirich. Margaret Weirich is an attorney with Iowa Legal Aid. Prior to coming to Iowa Legal Aid, Margaret spent almost 4 years at Prairie State Legal Services as an attorney, focusing on working with domestic violence survivors with protective orders and related custody and divorce cases. Prior to that, Margaret spent time working at the New Mexico Legal Aid and Legal Assistance of Western New York. So again, this is your opportunity to ask Margaret questions. I know I have some questions for her, but I want to give you all the opportunity to do that before I jump in. So I'm going to give you a moment to do that. All right, while folks might be typing or thinking of questions, I will get us started here. So from our previous conversations with member programs, we know that as restrictions on certain activities lessen, restrictions on businesses lessen, employees might be concerned for their safety if they return to work. But they might also fear losing unemployment benefits if they refuse to return to work. So what should folks know about their rights in that regard?
So as I think has been fairly well circulated, there is a provision of the Iowa Code that protects individuals if they cannot safely return to work to continue receiving unemployment. So that's the good news. The problem is it's hard to know what safe to work means for an individual. And there is no good answer to that. You know, is it safe to work if your employer provides PPE or protective gear? Is it not safe to return if you have a serious underlying health issue? You know, unfortunately, we can't answer those questions. Generally, it really has to be looked at on a case-by-case basis. So I unfortunately don't have a good answer except to say that there are protections and individuals need to consult attorneys, and Iowa Legal Aid is here to provide consultation through our COVID-19 hotline. And we specifically have a COVID-19 hotline set up that is dealing with specifically issues like this. And we anticipate seeing a real influx of these cases as people return to work in the very near future, possibly starting tomorrow. So that I don't know that number off the top of my head, but it's on our website. If you go to it, you cannot miss it. They can also come through our general intake line, which is both a phone number and you can apply online. So whatever is easiest for you. If they speak a language that's not English, we have Spanish interpreters available to do those intakes. And we will call someone back with just about any language that we can find on an interpreter service if they need a different language. They just need to specify what language it is, especially if there's a particular dialect. So we know there are a number of Burmese speakers. If they can specify if they're a Karen speaker or a Chinhaka speaker, that's going to help us make sure we call them back with the right interpreter. I will say the COVID-19 hotline is a voicemail box. They leave the information that's requested, and then someone will call them back to screen them and get them to an attorney. That is being staffed by a large number of people right now. I don't know the exact turnaround for the timeline on getting back to people, but typically our intake doesn't take more than 2 days to get back to someone, so they should receive a call back in at least that timeline, I would imagine, and possibly faster.
Awesome, thank you. Yeah, that was going to be my next question that you kind of already answered about. Are there any, legal standards around what constitutes unsafe workplace? But yeah, everyone's kind of figuring it out as we go.
And I will say, if you can have a doctor in the meantime provide documentation of the condition that you're worried about or the potential risk, if a doctor is willing to make a recommendation in writing about whether or not it's safe for that person to return to work, those are all super helpful things, because of course, a lot of this is probably going to come down to potentially documentation, and documentation that you gave the employer that information in written form. So there is nothing wrong with preemptively advising people to get information from their doctors, get it in writing, and then provide that information to employers. So if employers try and say later, we didn't know the risk, then you can point to a document that explained the risk.
Yeah, for sure. I think a lot of the advocates on this call are very familiar with the importance of documentation, so that's a great reminder. That's great, thank you. Let's see. And then I did have a follow-up question to that about if immigration status, like if someone is undocumented, or is there, might be on a work visa where their employer might be their sponsor. Does that affect someone's legal options around this at all, or what should they consider?
I mean, so, we used to say that no, that wouldn't have any effect. This day and age, we can't say positively. We haven't heard of anything that would indicate that there should be less protections for people that are undocumented. But of course, the risk to undocumented undocumented people is always real. And there's obviously nothing that prevents employers from calling ICE, from Immigration and Customs Enforcement, from taking other action, except that if they are knowingly employing those people, there's potential risk for the employer.
Okay.
So perhaps that person's in a unique advantage as opposed to a domestic violence situation or something else where there's no risk to the abuser reporting that person to ICE. And who is to say what ICE will or won't do these days? So we're not aware of additional risk, but like I said, there is always the potential for someone to use their immigration status against them. There's more of a risk for an employer to do that knowing they're employing somebody who's undocumented, but that isn't to say that it will prevent them. You can give me just a second, I have to plug in this headset.
Okay.
Sorry about that. I thought I had it charged, but.
No worries. Do folks have follow-up questions around any of what Margaret just talked about? I'll give folks a minute to type in the chat, or again, send me a chat or raise your hand if you want to be unmuted. Okay, if you do have follow-up questions, oh, I see someone. Sarah says, any input on those just struggling to pay daily bills, rent, utilities, etc.? So legal considerations around that, I guess.
Generally, no. Apply for government assistance where it exists, where they can get onto things like LIHEAP. I think that there are real possibilities of working with utility companies at this point. Utility companies do not want to be the bad guy in this scenario. The important thing with utilities is that you can work out payment plans with them, and payment plans must be reasonable. And the important thing is this: they can set up a payment plan. The payment plan should be affordable for them. The most important part of setting up a payment plan is that they have to make payments for at least 2 consecutive months after the payment plan is made, or they lose the ability to set up future payment plans with that utility company. So almost always utility companies should give them an option to set up a payment plan and to set up a reasonable payment plan. It says that it has to be reasonable. So if it's not affordable for them, then they shouldn't agree to sign on to it, because if they don't make at least 2 consecutive payments, then that utility company doesn't have to work with them in the future. If they do make at least 2 consecutive payments, then they still have the option of trying to work out future payment agreements if they get stuck again. And we don't want to give up that right, since we never know how long things like this will last. So not getting yourself into something that you end up not being able to fulfill is going to be really important, so that you're preserving that option for the future.
Great points, thank you. Okay, I have a couple questions coming in. I have one from Aaron, one from Iman, one from Claudia. Let me see what makes the most sense to ask first. Okay. Aaron, I see your question. It's a little bit more general, so I'm gonna hold off on it for just a second, and then I'm gonna do Claudia's and then Iman's, just for the flow of the conversation. So Claudia says, what if there is a parent in the hospital for COVID and the family is trying to get information on their parents' unemployment but need a POA?
That's a unique situation, but assuming that they can communicate with that person, see, I'm trying to think. So many of the notarization requirements for documents have been removed in light of COVID in order to prevent people from not being able to submit court documents just because they couldn't get to a notary over the past month. I don't know if POA or power of attorney is one of those documents. Possibly it's not, because it's such a sensitive document that the court might not want to take additional risks with it. But now that the state is opening up, whether for better or for worse, notaries should be more easily available. And I would think that a hospital would have notaries on hand. So it is completely possible that if they can get documents drafted up and to the hospital, they wouldn't need to see that person, that the hospital might have the ability to get that person to sign those documents, of course, assuming they have capacity and can sign those documents.
Thank you. Awesome. Claudia says thanks. So in the Q&A, Iman says, this is a little bit of a pivot. So asking about custody of kids when the mother doesn't feel secure for her kids from the abuser, helper services that Iowa Legal Aid could provide regarding this matter during COVID-19.
So unfortunately, there's not a lot of good news on this front. The Supreme Court has very clearly issued rules saying that visitation is to be treated as if regular visitation were occurring, because it is. That COVID-19 is not a reason to suspend visits, prohibit visits, or otherwise keep children away during regular visitation time. Any parent that does is risking, I'm not saying it will happen, but is risking being found in contempt for not allowing that visitation to occur. Now, if that visitation is ordered out of a protective order, that's potentially something that comes with jail time if they're violating that protective order by not providing the child or children at the time they're supposed to. If it's in a custody or a divorce case, there's also the risk of jail time, but additionally, there's also the risk that the court could use the prevention of visitation to actually switch who is the primary caregiver of the child. That is an option in divorce and custody cases. So there are real risks here to potential primary custodians, or two primary custodians who potentially the other side could ask for that primary custody label to be given to them if the other parent is inhibiting visitation. COVID by itself is not a reason to prevent visits from happening. Now, if there are real risks to the child, and I don't just mean mom is worried because dad is working, or mom is worried because the child gets sick easily, but if child has a real documented by a doctor underlying medical condition that puts them at serious risk, then you could petition the court to ask for a modification, but you cannot unilaterally decide not to allow the other parent to see that kid. You need to do a motion to the court and ask the court to take the risk into account and see if the court would go ahead and temporarily modify the visitation. Now, if other parent is willing to agree not to see the kid or to modify visitation, get it in writing. Even if it's in a text, even if it's in an email, just needs to be something to show that later, if that parent comes back and says, oh, they denied me parenting time, that there is actually a piece of writing, an email, a text that says, oh, sure, I don't need to see them this weekend, or no problem, let's hold off until things change. So it doesn't need to be a notarized piece of paper. It does need to be some sort of documentation showing that this wasn't just one parent preventing the visitation from occurring. Judges will take into consideration the reasons people make these decisions, but that doesn't mean that they won't hold parents in contempt if they feel like another parent wasn't acting reasonably. I can't say that you need a doctor's letter, but I feel like a doctor's letter would go a long way. If a doctor is recommending that visits don't happen because of a medical reason, and you could present that to a court in a written form, that might go a long way towards avoiding a contempt, but we can never promise you what a judge will or won't decide when it comes to a contempt hearing. It's very fact specific.
Thank you. Does that answer your question, Eamon? Okay. Aaron asks, what are the most frequent questions or cases that you're seeing at this point?
Well, I'm not staffing our COVID-19 hotline, so I'm not specifically dealing with those things. I would say, if I had to guess, it's the unemployment issue because people are afraid to go back to work. It's definitely dealing with the stimulus payments that were sent, especially if they were sent to the different parent that no longer has the children in their possession. And we have seen a spike in protective order hearings in just the past like 2 or 3 weeks.
Interesting.
We expect to see a large increase in divorce cases when this all ends.
Yeah, I've been seeing jokes about that, but that's real.
It's a real thing.
Yeah, definitely. All right. While folks might be typing or thinking of other questions, I do have a couple other ones that were on our mind. So we've been getting questions from some programs who serve clients who have mortgages and are struggling with getting the appropriate documentation from their mortgage lenders in order to get some relief. So is there anything that folks should know around that in terms of their rights or when they should consult with an attorney in terms of borrowers' rights?
Sure. So I'll just look real fast. So there is a moratorium right now on the filing of foreclosures across the state. Nobody in the state right now can file a foreclosure no matter what. The governor has prevented that, and the courts aren't even accepting the filings right now. Yeah, and I don't know, it's not clear when that moratorium will end. That may also end on May 27th when almost all of the governor's moratoriums expire. But the court's website doesn't have a specific date on that yet. But I would anticipate that that is probably a moratoria that ends on May 27th. So the good news is prior to May 27th, nobody can file a foreclosure. And people should absolutely be calling their mortgage companies, working with their mortgage companies. Mortgage companies do not want to be the bad guys here, which doesn't mean that they won't foreclose on people. I'm sure they absolutely will. But I think there is some goodwill to be had hypothetically. And so people need to be in contact with their mortgage companies, trying to work out payment plans, seeing what they can do. I expect there will be potentially a large number of foreclosures filed once the moratorium lifts at the end of May. Here is some things that people should know. This isn't specifically for owners, but for people, this is for renters who live in properties that have mortgages on them. Now, that may not be something that people know, but hopefully it's something they could ask their landlord and find out. If you have a client who lives in a property that has a mortgage on it, and that mortgage is federally connected, which experts estimate something like 75 to possibly 90% of the mortgages in this country are, then they cannot even give a notice for an eviction until July 25th. So if landlords own their properties outright, there's no additional protection. But if a landlord has a mortgage on an apartment building, a home that they're renting, condos, whatever it is, and that mortgage isn't paid off, and that mortgage is federally connected, which, as I said, most of the mortgages in this country are, then as of July 25th, they can give a 30-day notice. Not a 3-day, the way we normally would expect with renting. This is a federal mandate. And so it says you can give a 30-day notice. And actually, the date may be July 25th or 27th. I can't remember off the top of my head, but somewhere right around there. So then they have 30 days from that date. So we're talking August 26th or 27th is the earliest that if someone weren't out of the home and weren't paid up, that a landlord could then go ahead and file an eviction against a tenant if they have a federally connected mortgage on the property. Now, the problem we have not figured out, and I know that there will be solutions for this, but I don't know what they are yet, is that we don't know how to make landlords prove that they have they do not have federally connected mortgages before they proceed with an eviction. That's not something you normally have to plead in an eviction case, because normally we're not looking at whether or not they have a mortgage, much less whether that mortgage is federally connected. So it's an unusual circumstance, but something we will be looking at closely come the lifting of the moratoria on evictions, which we anticipate will also lift on May 27th per the governor's order, is for renters, are those properties with mortgages on them, and are they federally connected? Because if so, the fact that the state moratorium on evictions ends on May 27th is irrelevant.
Interesting.
Yeah. Am I going all right for you, Madam Interpreter? Okay. I have a habit of speaking too fast, so I'm working on it. So that's a lot of information, but about both people who own and renters. If people have follow-up questions, I'm more than happy to try and answer those.
That's great information, though. Yeah, that's not something I'd seen elsewhere. I keep seeing the May 27th date, but that's about it.
The federally connected mortgages are going to be really important to giving people months of extra time to either get caught up on rent or figure out where they're going. Like I said, I don't know yet how we're going to make landlords prove that, but it is something we will be figuring out as we go along, so stay tuned.
Mm-hmm. Awesome, thank you. I'm going to give folks another minute. I see there's one question in the chat, and I know Iowa Legal Aid is you're all civil, you all do civil legal work, not criminal, but if you have any if you've heard anything or know anything about this question from Sue, she says, incarcerated persons during COVID, although the state indicated an intent to release elderly, ill, incapacitated persons in light of COVID, and there were large numbers floated, do you know if there are any inmates that have actually been released in Iowa?
I can't say for sure in Iowa. I know I've seen across the country, we have seen releases. I also haven't been paying attention to that. So just because we don't focus on criminal work at all. So it's possible that's happening and I'm just not aware of it. I do, actually, some of my clients have relayed to me that people that they did not anticipate would be released have been released because of COVID. So I think that may be happening on some level, although how accurate that reporting is from clients, I can only guess. But so there may be some of that happening on a state level.
Okay, interesting. All right, thank you. All right, yeah, please continue to type questions in chat or Q&A, or let me know if you want me to unmute you to ask a question. So this is kind of going back to the first question about safe working environments and workers' rights and things like that. So I know we have, let me check and see who's on, on this webinar. We might have a couple of folks who are program directors or executive directors who are trying to figure out how best to support their staff during this time. And everyone's kind of figuring out how to safely, if you need to send someone out on a call or meet a survivor somewhere, what's the best way to do that? Are there any standards or best practices that you're aware of around PPE, hazard pay that employers should be aware of in terms of maybe their liability or just making sure that that they're adequately protecting the safety of their staff?
Right. So I don't have a whole lot of information on that at this point, unfortunately. I think we're still working towards developing standards on this issue. The little I do know is that it is less of an unemployment issue and more of an OSHA issue. I forget exactly what OSHA stands for, but deals with safety hazards, things of that nature. So OSHA is going to be the organization that deals with complaints about unsafe work environments. And I believe that's where complaints would be directed if employees feel they're not being adequately protected. Unfortunately, I'm not sure yet what those best practices look like. At Iowa Legal Aid, it's just making sure everyone has masks, making sure that we have hand sanitizer and Lysol wipes, but I can't say for sure in terms of legal protections what that's going to rise to. Yeah, unfortunately, we don't have a good sense of that yet, so I don't have good answers around that.
That's okay. Yeah, I think, in relation to the first question, there's not really that standard of what is safe versus unsafe, where that boundary is. And so it's hard to draw the line around that. Let's see, other questions that folks have. All right. While folks might be typing things out, just a follow up to the mortgage question. So I know we've talked with some programs who have had trouble with getting the documentation that they need from their lenders because then it would make it, or the lenders believe that it would make it harder for them to foreclose on these clients once protections end. Is there anything that have you heard anything about that happening? Is there like documentation that these folks should be keeping? Like we requested, this from the lender, but they wouldn't give it to us, or anything like that they should be doing?
I mean, I haven't heard specifically, like I said, because I'm not doing COVID specifically related intakes. That may be going on. I just don't know about it. But I just best practices always keep documentation of any sort of request that you send to the lender. If you do it in an email, print out the email. So if your email gets hacked, you don't lose it. If it's a phone call, maybe you do a screenshot of the phone call log and upload that to an email so you don't lose it if your phone breaks. Always have documents in other places. If it's a letter, send it certified so that you get back a green card showing they received it. If it's a fax, print the fax confirmation sheet and keep that. So anyway, you're sending these things, and I would send them multiple ways just to be safe. Typically between emails and phones and online submission forms, you can do that hopefully with minimal cost to clients. And then obviously keep any responses back from a lender. But I think that's just best practice all the time, even during non-COVID times, but particularly if those are going to be issues that arise later when there's hypothetically a crush of foreclosures or something like that. Those requests may be very important in terms of timelines. So yeah, absolutely keep and document as best you can.
Yeah, thank you. Definitely. All right, I'm looking to see if we have any other chats. We don't have any yet. Sometimes it takes folks a minute to formulate their thoughts. That's totally fine. I know I have a couple of coworkers here as well with the coalition, so you guys let me know if anything is coming up for you. Looking back at my questions, but I think you were pretty thorough. And then also with that last issue that I raised about being at an impasse with some of these mortgage lenders, has anyone in the audience had any success in getting through to lenders or successfully advocating in those systems that you could share with the rest of us? Looking for any tips or information that folks in the audience might have as well. Okay, I'm not seeing any other questions. Thank you so much, Margaret, for answering our questions and the pretty wide array of questions that you just got from us. Really appreciate it. And I will be sending out a follow-up email to everyone who attended with some of the resources that you referred to, the Iowa Legal Aid COVID line. I'm gonna probably send a link to the OSHA website, see if they have any best practices or information for folks. Yeah, we really appreciate you joining us and answering our questions, and hope you have a great rest of your day.
Thanks, and you guys, someone on here has my contact information if there are more specific questions or issues, or if any of you are hearing of issues, large systemic issues, particularly access to courts for domestic violence victims or just other clients that aren't getting through. We want to hear about those things and we want to address them. So please send those our way if you're finding that there's a lack of access for certain kinds of clients. But thanks for having me.
Yeah, thanks so much. And everyone who attended, please, if you haven't put your name in the chat already, please do that so I can make sure that I count your attendance. All right. Thank you, everybody. Have a great evening, and we will be in touch soon.